I
would like to welcome the representatives from the administration to join us. I would like to continue with our discussion. And then this is about the draft live television link, witnesses outside Hong Kong rules, and draft rules of the High Court Amendment rules. The relevant document is paper CB bracket 4853/13-14 bracket 01. This is the admin's paper entitled Draft Live Television Link, Witnesses Outside Hong Kong Rules, and Draft Rules of the High Court Amendment Rules. Members, please note that this is in accordance with the Evidence Miscellaneous Amendments Ordinance 2003 in relation to Part 3. And then the Law Society has also made a number of comments concerning the draft rules of the High Court Amendment Rules, in particular Section 4, that is the way that questions are to be put to witnesses, as well as Section 7, that is the drawing up, certification, and transmission of minutes upon conclusion of an examination of witness in Hong Kong by way of a live television link. It is hoped that in 2014 the rules can be introduced, and there should be it should be subject to negative vetting.
So may I invite Madam Wan to do a presentation? Yes, please continue. Yes, he just wants to ask a question. That should not affect you. The administration has already submitted to the panel a paper, CB bracket 4853/13-14 bracket 01. This briefs you two sets of rules we would like to submit to LESCO. They are draft live television link, witnesses outside Hong Kong rules, and draft rules of the High Court Amendment rules. We would like to obtain your support so that we can start the legislative work as soon as possible. Back in 2003, the Evidence Miscellaneous Amendments Ordinance was already passed, covering a number of local legislations, including Evidence Ordinance, Criminal Procedure Ordinance, Mutual Legal Assistance in Criminal Matters Ordinance, Crimes Ordinance, Magistrates Ordinance, Mutual Legal Assistance in Criminal Matters Regulation. The purpose is that we can introduce a new way of obtaining evidence, which is via live TV link. Certain provisions of the draft rules have come into effect in 2006 to facilitate overseas authorities, including government bodies, to put forth a request to the JA in Hong Kong so that they can use a live TV link to solicit evidence from witnesses in Hong Kong for the use of overseas courts. That part is already in effect. So Hong Kong is providing assistance to overseas courts via live TV link. But for the domestic criminal procedures in Hong Kong, if we would like to obtain evidence from overseas witnesses via a live TV link, it is currently not possible, and therefore we need to wait for the enactment of these subsidiary legislations before we can make that happen. So we have provided the 2 draft rules. The first one is draft live TV link witnesses outside Hong Kong rules. It is to amend the CPO. If you refer to our paper, Annex B, you can see the original draft of, you can see page A90279I, providing discretionary power to local courts so that both parties in a criminal procedure may allow witnesses other than the defendant when conditions are deemed to be suitable through live TV link provide evidence to the domestic court. We have prepared the first set of subsidiary legislation, and you can see the provisions. They are mostly procedural in nature. For example, how to make an application, how do you object, who needs to be served concerning the application, so on and so forth. For the second set of rules, they are the High Court amendment rules. So this is about amending the evidence ordinance. Right now, local courts do not have the authority to provide assistance to magistrates or courts overseas. In other words, proceedings taking place in overseas countries, if you would like to use live TV link to question the witnesses, it's not possible at the moment. When the second set of rules come into effect, Court of First Instance in Hong Kong will have the authority to do so. So we plan to amend the RHCR. Both rules are quite technical in nature, so we have consulted the Bar Association and Law Society. Back in 2009, the Bar Association expressed that they had no further comments. But in early 2010, we got some comments from the Law Society expressing a number of concerns and questions. The administration, through meetings and written correspondence, we have provided them with our response and our viewpoint. You can refer to Annex E and F for the details. In response to the Law Society's request, we have also amended 8(1)(b) of the LTVL rules. So both sets of legislative amendments have obtained the approval by the Chief Justice of High Court, and we have been asked to consult this panel. Once we obtain your support, we will start the legislative process ASAP. Thank you, Ms. Wan. From the Bar Association, Mr. James McGowan.
Good afternoon, everybody. As you know, the Bar really has expressed its views in the past. It doesn't have very much to add. It's probably more a wish, not tied into the rules itself, that this form of assistance will also be made available to defendants in trials if they wish to have evidence by the same means overseas, and that legal aid will be granted in appropriate cases for that. That's really outside the term of the rules, but that is one of our concerns, that this provision should be applied even-handedly between the prosecution and the defence. Other than that, I have no comment.
Okay.
All right, thank you, Mr. McGowan. Now, let me invite Mr. Stephen Heung from the Law Society of Hong Kong, the President. Yes, Chair Lady. First, I know that we were late, so sorry for keeping you waiting. No. We finished early, ahead of schedule for the last item. our apologies anyway. The Law Society has already provided all its views in our written submissions. I want to explain why we have so much reservation during this consultation exercise. This method to collect evidence will provide more assistance to the prosecution side rather than the defendant side. Hong Kong already uses video link to collect evidence from vulnerable witnesses, but they are here in Hong Kong. They are just hidden in one of the rooms in a local court. But now we're talking about overseas witnesses. So I would like to state one more time our greatest concern is if this witness provides evidence that is not totally true, what channels do we have to hold him or her responsible? Because this witness is outside of Hong Kong. So perhaps the witness doesn't have to be so cautious in providing evidence. The DFJ has not responded to this point. While they understand this is a possibility, how should we handle this? From my standpoint, I'm not totally satisfied. So at this meeting, I would like to say that we don't want to see this method to be exploited when witnesses feel reluctant to come to Hong Kong to provide evidence. Again, it provides more assistance to the prosecution side. Thank you, Mr. Heung. Now, members, may I invite your questions? Who would like to speak? Let me read the names. Mr. Colin Heung, Leung Sing, and myself. So far only 3 members. So 5 minutes each. Mr. Kok. Thank you, Madam Chair. I think the President of the Law Society stated one important issue. Under what circumstances should we permit a witness to collect evidence via live TV link from an overseas witness? 79I per 2, I see some considerations that the court have to consider. So for such reasons or justifications, do you think they are sufficient in resolving partially the concern of the Law Society, which I think are totally well justified? 79I2, right? There are 5 considerations. Do you think we can do anything to enhance such conditions? Thank you for the question, Mr. Kok. You are correct. 79I, Annex B, A 903, it lists out 5 conditions. When any of these conditions are met, then the court shall not give permission for live TV link. The items D and E are more relevant. The Law Society's concern were expressed back in 2002 and 2003 when this ordinance was being considered by LegCo. At the time, in response to their concerns, we have added some provisions. Item D, measures to ensure that a person will be giving evidence without coercion cannot reasonably be taken. In other words, if this overseas witness is providing evidence via live TV link, if you cannot see if this person is under the threat of force, or this person may not be able to provide evidence on a voluntary basis, or you feel that he's not telling the truth, because this mechanism can be used by the prosecution side and also the defendant side. If there are concerns on the defendant side, when the prosecution side applies for the TV link option, they can point out to the court that there must be some sort of assurance that this witness, while providing evidence, is not under coercion. If members can refer to Annex A, we're planning to submit this to LESCO. 6(2). 6(2). We allow the court, when permitting the use of live TV link, to impose additional conditions. The witness must provide evidence in the presence of certain people. So while under oath, this person must be able to answer questions put forth by the court, including a question about any person who is present when the evidence is given in any matter which may affect the giving of the evidence. So the assurance mechanism is already present, so that the person can be present overseas to respond to questions concerning the circumstances in which the evidence is given and the people who are present when the evidence is given.
So this is the first safeguard. And then for the second one, please go back to 79I and please take a look of 2E. If it is to be granted, it should be in the interests of justice to do so. So if it is not in the interests of justice to do so, then the court should not grant permission. So the court would want to know whether it would be not to the interest of the defense, then the court would consider otherwise. Next, Mr. Ng Sing. For the live television link, in fact, when we hold directors' meetings, from time to time, we have resorted to such a mode. So my question is, what is the international practice? Say, for example, in the case of criminal offenses, when lives have been lost, I want to know which countries or which regions have established a good experience in the use of live television link, and then it said that the witness should not be made to give evidence under coercion. Please tell us if you have got any cases which are not sort of favorable. Under Cap 525, in particular Section 10, the relevant provision has been passed. There's in relation to mutual legal assistance in criminal matters regulation. Therefore, all along, we have been providing assistance to overseas governments so as to facilitate the taking of evidence via live television links. The United States of America, the United Kingdom, Australia, France have been using live television links, and even the Netherlands. I recall that the first such case was from the UK. At that time, there was a murder case in the UK. They had a very important witness who returned to the mainland China. The witness said that he or she would not returned to the UK to give evidence, since the witness had been employed by a company recently, but he would be passing Hong Kong. So he was willing to give evidence in Hong Kong via the live television link. So we were linked, and then the prosecution and the defense put a lot of questions to witnesses. They examined the details, and it was very successful. As to whether there was a very bad case, the witness was found to be telling the lies, etc., we haven't got such a record. We haven't got such examples with us. But then in Hong Kong, the witness will have to give evidence under oath in accordance with the laws of Hong Kong. So in case of giving false evidence, the witness will have to bear a criminal liability. I want to know whether this can only be provided when there is the mutual legal assistance, so that there will be the extradition. Or is it simply a case of just giving evidence and then nothing would come out of it? And what about the payment of fees or costs implications? Well, as to whether there is anything under the convention to extradite the defendants, I don't think this is the prerequisite for providing this assistance. According to CAP 525, Mutual Legal Assistance in Criminal Matters Ordinance, first of all, we need to have a multilateral or bilateral agreement. And we have to be satisfied that there will be a promise to give assistance in return. Well, this is a matter of giving evidence as to whether it would result in a successful conviction and then leading to a request for extradition. Well, according to our laws, there must at least be a bilateral or multilateral agreement to deal with such matters. What about the costs and the fees? Well, for live television link under CAP 525, the requesting party will bear the cost. What about liability? I will follow this up on your behalf later on. Does any other member wish to speak? Well, I myself would like to ask this question for both the administration and others. And just now, Ms. Wen has said that it will be a witness giving evidence under oath. But then in overseas countries, witnesses may casually give evidence despite giving evidence under oath. So what can you do about it? And then Mr. Ng also asked a very valid question. That is, in the absence of mutual legal assistance in criminal matters, well, the witness may very well be giving evidence under oath overseas. Now, evidence is given, then some parties in Hong Kong may be convicted. Can we hold the witness liable, accountable? On my part, I've always been in favor of mutual legal assistance in criminal matters, because we don't want to become the haven for criminals. Now, maybe the administration can confirm me on this point. First of all, there was the taking of hostages in Manila. That's the strategy. Our coroner's court has asked for witnesses to come. Well, if under oath they just give us part of the truth, what can we do? And then Hong Kong and the mainland are two different jurisdictions, and we haven't got the mutual legal assistance in criminal matters agreement. Of course, there can be assistance in other aspects. Now, in the future, maybe, well, in Hong Kong, if you breach the law in Hong Kong, then you can hold the offender liable. It seems that the Law Society has got valid concerns. Can you address the concerns? Ms. Wen seems to rely on the fact that witnesses will be giving evidence under oath. Thank you, Madam Chair, for your questions. For taking oath overseas, whether it has validity in Hong Kong, the answer is in the affirmative. For the evidence, MA Ordinance 2003, you have Section 79J, which makes it clear that now if you give evidence in proceedings outside of Hong Kong, in such cases you will be deemed to be part of the courtroom in Hong Kong. In other words, as far as the proceedings are concerned, the same would apply. And then that subsection has effect for the purpose of laws enforced in Hong Kong relating to evidence procedure, contempt of court, and perjury. So if somebody is to give false evidence via the live television link, this person will be held liable for contempt of court and perjury, etc. You may very well say that he's outside of Hong Kong. Should there be an extradition treaty or agreement, then it will be fine. But in the absence of that, what will happen? Now, even in the absence of live television link, what do we do currently? We fly the witness to come to Hong Kong. We fly the witness to Hong Kong. He has left. And then if it is found that he has given false evidence, if there isn't any extradition treaty, what would happen? I think the same would apply. So it isn't hinged on the live television link. Therefore, we believe that we haven't created a new problem here. As to the arrangements between Hong Kong and the mainland, maybe Ms. Lee can supplement. Yes, Ms. Lee, thank you, Chair, for your question. You have rightly pointed out that for the proposed amendments and with the introduction of the rules, we may see a lot of requests for taking evidence. I think you understand that Cap 525 doesn't apply to the arrangements between Hong Kong and the mainland. So we have to rely on Cap 8, which is the evidence ordinance, so that it will be a court talking to another court, making the request. We of course appreciate the possibility, but then we are confident in our lawyers. I'm sure lawyers can ask precise questions, and then we can reduce the problems. And then we have immediacy when we have live television link, and should there be any problems or questions, they can be followed up. Any other questions? Mr. Ng Liang Sing. I would like to continue with my earlier question. That is the cost. Just now, Ms. Wen has said that it is just the same, but I don't think so. You can imagine that if we have got extradition arrangements, then you will be encouraged to cooperate. Otherwise, it may not be useful, because even if evidence to be given is useful, there's no follow-up because there's no extradition. So perhaps we should study the matter further. That is, when we cooperate with the relevant authorities, if there is an incentive, should we always do it? And then if we just pay lip service, we just do it half-heartedly. Of course, you've said that you didn't have such bad precedents, but then we can't rule out the possibility, because the other side may just do lip service to us and may not take the request seriously. I'm afraid in this case it will be counterproductive, because the evidence that we gather is not accurate and may not be relevant. So please comment on my concern. Ms. Wen, thank you. I think we have to look at it in this way.
If a witness provides untrue evidence, and such evidence is to be used in the court in Hong Kong, and it can be ruled out later if it's found to be untrue. So in a criminal procedure, it cannot be relied upon. Even if you don't use the TV link, if someone provides false evidence, the consequences are the same. So if you later realize that the evidence given is not true, so concerning this offense of perjury, can we have him extradited to Hong Kong? I've already added that even without the TV link, this person provides evidence and then leaves Hong Kong, you cannot catch him afterwards. So a witness providing evidence, and where he's providing evidence, the place does not have extradition agreement with Hong Kong, the evidence will be heard anyway, but whether it is to be relied upon, the court is to decide on its own. Mr. Ng, any follow-ups? It's okay. To be honest, I'm not totally happy. If we begin to use this TV link, the cost may be substantial. And today we need more manpower in the judiciary because they have such heavy workload. If we are to add something that actually goes both ways, we can make a request and we have to provide a service to other parties making the request. So if we are to embark on such new services, we have to think about the cost and reasonable outcome. Sounds to me that it is not totally satisfactory, but if it is indeed the new trend or international need exists, I am not going to object. Chair Lady, it's been going on since 2006. Hong Kong has been providing such services via live TV link to overseas jurisdictions. So what we are doing now is to make this an arrangement that is mutual. If we don't make such amendments, we cannot ask for assistance. If overseas witnesses are reluctant to come to Hong Kong to provide evidence, the entire team, the legal team, will have to fly there and collect the evidence in overseas place. And the cost is very big. If we can use the TV link, of course, there will be 79I conditions that will have to be met. There's no hindering of judicial we just have to provide the cost for the internet, basically. Mr. Chen Kam Lam for the first round. I heard from the Law Society, Mr. Heung said he doesn't really agree with this practice because it provides more help to the prosecution side or the defendant side. So when you considered this practice. Do you agree that this method may be used more so by the prosecution side rather than the defendant side? I would like to know. Why you don't agree with this proposal? Can you tell me sort of the split between the usage by either side? Let's go back to the basics. Why don't witnesses want to come to Hong Kong? Maybe they are ill. That's quite reasonable. But if the person doesn't want to come to Hong Kong, because once they enter Hong Kong and provide evidence, and they provide false evidence, they will be subject to the local laws. Not every court is equipped with a live video link. Perhaps they end up in a hotel room somewhere. That is the greatest concern of the defendant's side. How come this person doesn't want to come back to Hong Kong? Something must be going on, and the government is saying, "Oh, the court can decide." In that case, the interest of the defendant is neglected. And secondly, in comparison, the defendant's side won't use this method as much, because if the defendant's witness is willing to attend court hearing to provide evidence, this person will automatically turn up. Unless this person is very ill or physically unable to fly to Hong Kong or commute to Hong Kong. Otherwise, this defendant witness must be a voluntary witness. The prosecution side may use this video link to compel witnesses who are reluctant to come to Hong Kong to give evidence. That is why the Law Society has been going back and forth on this issue, and we still have our reservations. In terms of Hong Kong asking overseas witnesses to come to Hong Kong, it doesn't happen that often. If we are offering assistance to other jurisdictions, as a member of the Hong Kong society, we're happy to help. But it doesn't mean that at the same time we must ask for the same thing from other jurisdictions. Okay, Mr. Chen, I have a follow-up question. It is possible that the defendant has some overseas witnesses who may not be able to travel in time to Hong Kong to provide evidence with the video link or the TV link. Such witnesses may provide evidence in an overseas court to support the defendant's case. So why don't you like this idea? You keep saying that if he's willing to testify, he'll fly to Hong Kong. Maybe it is not convenient for him to do so. Why don't you agree to letting him testify overseas? Well, the defendant is not legally responsible or liable to disclose what the witness may say. But for the prosecution side, what their witnesses are about to say will be made known to the defendants. So if the defendant is to make an application, we have to inform the court why we want to use the TV link. So I'm saying defendant's lawyer must consider thoroughly. He must balance at the stage of application. If he is to disclose to the prosecution side what his witness may say at this stage, before the witness actually testifies, the prosecution may conduct further research or investigation. If we turn things around, there is no problem because the defendant already knows what the witness is supposed to say in court. All right. Mr. Chen, you want a second round? I actually have a follow-up question. First of all, concerning the Philippines case. If this person flies to Hong Kong to testify, he is physically in the Hong Kong court. So he must take it seriously. If he lies, he's liable to heavy penalties because it is contempt of court. But if this person is testifying in another country, if we consider the place where he's testifying, if he lies, is he going to be held in contempt as well? Are you going to make such request to have equal treatment? If they break the Hong Kong laws, they can only be prosecuted if they are physically in Hong Kong. It actually goes both ways. So I want to hear about the Philippines case. If their witnesses just casually provide some sort of evidence and then you have to draw a conclusion, if they lie in court, or they do not present the entire truth, how do we deal with such liabilities? Can you spell out more information? And what about cost, as Ms. Ng Leung Sing has asked? Can you tell us whether the cost will go up substantially? Concerning the Philippines case, I will ask my colleague Ms. Lee to respond. My unit is not responsible for the Philippines case, but it is a coroner's court. In our law, that is not civil in nature, nor is it criminal in nature, because it does not seek to decide who should be held liable. And for CPAO, it does not cover the work of coroner's court. So the Philippines case is very unique. It is sort of outside the existing evidence collection mechanism. So if we are to use it as a case study, it will be quite difficult. But if the procedures of taking oath is very different between the two places, or it is simply not in existence in one of the jurisdictions, how do we deal with such discrepancy? As you have pointed out, evidence given in overseas place will be deemed as part of a Hong Kong law. So if they do lie, they are breaking the Hong Kong law. Or in that jurisdiction, they do not have oath-taking procedures. Well, we have never seen such cases because we have never made a request to overseas jurisdictions to collect evidence from overseas places. Even if they do not have oath-taking procedures, they should have a very serious declaration. We will ask the other jurisdiction to conduct that declaration procedure so that the witness understands that in case of perjury or violation of the declaration, there will be consequences. Of course, every case is different, and we have to consider how we deal with the discrepancies in reality. So it is a matter of monitoring the situation. Sometimes a witness may end up in a hotel room because there are no proper facilities available. But this is a very serious criminal case for Hong Kong. they make a declaration. It could be very serious, but in that jurisdiction, contempt is not a serious matter, perhaps. How do we make sure that it is something equivalent to contempt in Hong Kong? Are you going to think about that? If the regimes are comparable or similar, the declaration would be more meaningful.
Thank you, Madam Chairman. For each and every request, it depends on the arrangements of the country or the authority that we put our request to. But your suggestion is good, and I'm sure we can sort of add this specific request. Any other questions? Bar Association, Mr. McGowan, and also Mr. Heung from Law Society. Do you have anything else to add? No, not from me. Thank you, Madam Chair. Well, in this case, I'd like to put a question to members formally. The administration would like to introduce the legislative proposals to LegCo. Probably we have to set up a subcommittee. I think this is something new, and we thank the Bar Association and Law Society for assisting us in this case. Thank you. And that takes us to the last item on the agenda, which is 2014-15 Judicial Service Pay Adjustment. So we will take a look of paper, which is LegCo Brief CSO/Admin CR6/3221/02. You can also refer to the background brief prepared by the LegCo Secretariat, CB-4 172/14-15-04. I'm sure the panel is very familiar with this topic. The Standing Committee on Judicial Salaries and Conditions of Service, Judicial Committee, has recommended an increase by 6.77% for the pay for judges and judicial officers with effect from the 1st of April 2014. I would like to give the floor to Ms. Kitty Choi, Director of Administration. I assume that members have read the paper, so I'll be brief. For the mechanism to decide on the pay of judges and JOs, it has been delinked from that of the civil servants. Well, every year, the CE in Council would consider the recommendations of the Independent Standing Committee on Judicial Salaries and Conditions of Service, Judicial Committee for short. We have a regular benchmark study to look at the pay comparisons with the legal sector to see whether the differences have been broadened or not. We do it once every 4 or 5 years. The last one was carried out in 2012, so the next one will take place in 2015. For the second part, we are talking about a yearly pay review. In the year 2008, the Executive Council has decided on a basket of factors. In other words, we have to look at a number of elements before we come up with the pay adjustments. So the current exercise is the yearly pay review. We look at 3 major issues. First of all, we want to uphold the principle of an independent judiciary. And then we would like to look at the judiciary's position, that is, the views on the pay adjustment. And then the CE Council has laid down a basket of factors in the year 2008. So you see the details in the paper. I don't want to repeat the details. But today, I would like to draw your attention to 3 points in particular. First of all, the workload. I'm sure members are concerned about the workload of our judges. You want to see whether the workload has been increasing with time. For the current report of the Judicial Committee, well, the workload is stable, but then with growing complexity. And there is a higher ratio of unrepresented litigants, and this is particularly the case for the High Court. And as a result of the increased complexity of the cases, you would note that earlier on the judiciary has already obtained resources to have 7 additional judicial posts at various levels of the court this year. And in fact, we are also going through the process of the ESC of the Finance Committee of the LegCo. Once we have gone through that, then we will go to the Finance Committee of the LegCo. So the first point is about the workload. The second point is about recruitment and retention. I would like to update a figure in the paper. According to the paper, we have got 154, but then as of October, the figure has been revised to 170 for the JJOs. I think retirement is a major reason for wastage. For paragraphs 8 and 9 of the paper, I think you must have noted that for the first time, the judiciary has told us that it seems that there are some initial signs of difficulties at the recruitment of Court of First Instance judge and engagement of deputy special magistrates. We would like to draw attention to paragraph 9, which says that the judiciary is of the view that at this stage there is no conclusion as to whether there are genuine recruitment difficulties. They want to wait for the outcome of the latest recruitment exercises. And then we have got a total of 170 now instead of 154 post holders. And then in October this year, for CFI judges, we've just started a new round of recruitment. I'm sure the judiciary would also await the outcome of this recruitment exercise to see whether the response is better than previously. And then in the following year, the Judicial Committee would come to a view as to whether there is a need to make a change in the pay adjustment in relation to recruitment. And then private sector pay levels and trends. I think you would understand that there isn't a comprehensive or representative pay trend survey on the legal sector. The work of the judiciary is also very unique. The Judicial Committee doesn't think that there should be a direct comparison between judicial pay and legal sector earnings. In 2010, there was a benchmark study on the earnings. It is believed that the differentials between judicial pay and legal sector earnings do not point to any specific trends. And again, the study has reaffirmed that remuneration was not an important factor in considering judicial appointment. The Judicial Committee continues to make reference to the pay trend indicators from the annual pay trend survey, and then the Judicial Committee will continue to look at the upper pay band. But then increments, that is both merit and in-scale increment in the private sector, would be included in the gross PTIs. So in order to compare like with like, for the gross PTI of 6.91%, the consolidated cost of increments should be taken out, and then the final figure after adjustment is 6.77%. So we have looked at a basket of factors. We have looked at the broad principle of judicial independence. We have looked at the position of judiciary, and therefore the recommendation is a pay increase of 6.77%. Thank you, Ms. Choi. 5 members would like to speak: Mr. Tan Ka Bill, Ms. Emily Lau, Mr. Dennis Kwok, Mr. Leung Sing, and myself. I would suggest that 4 minutes each, so as to allow the administration and the Law Society to give us their comments. So maybe Law Society, Mr. Heung. Thank you, Madam Chair. First of all, it's only when I read this paper then I knew that in 2010 there was a benchmark study on earnings of legal practitioners in Hong Kong. It appears that the Law Society was not consulted when the study was prepared. I did also ask my colleagues. We were not aware of having such a study. It may appear that it has no direct relationship with the Law Society. However, when you try to recruit lawyers to join the bench, had you consulted us back then, we would have given you a lot of useful information. Let me be brief here. I have a number of points to make. For judges in Hong Kong would be the least vocal group to speak up to fight for their interests. Therefore, when you carried out the study, I would like to know whether you had gone to ask for the opinions of the sitting judges as to whether they were satisfied with their earnings. In the year 2008, I think that's the year when our economy was in a very bad shape. So maybe it's a matter of the base year rather than a matter of the percentage of the yearly increase. I understand that the pay has been delinked from that of the civil service. But then for ordinary people, as far as the Chief Justice, as well as the Chief Justice of the High Court, they may not understand why there is such a huge pay difference between such judges and the senior officials of the administration. Of course, it isn't the dollar sign that have attracted our colleagues to join the bench, but I do understand why some of us are not willing to go to the judiciary. First of all, the supporting staff. Maybe I would like to make this suggestion. Maybe you should have junior lawyers, whether they are solicitors or barristers. Those have a shorter period of experience, they should be recruited into the judiciary so as to assist the judge in doing the research work. Currently, I think judges are relying on non-qualified staff, or they don't have any support in of this nature at all. So as to make the judiciary more efficient, I think the government should consider the creation of such posts so that qualified personnel would be recruited to do this job. According to the paper, it appears that there aren't any major problems. I understand that when the judiciary considers a candidate for the bench, they have very high standards. Yes, there are many people applying for the job, but then they are not up to the requirements of the judiciary. So why is it that those who are qualified are not applying, but others who are still a bit short of the requirements are interested to apply? Probably it all boils down to the question of remuneration. Now, for the Law Society, I think maybe we don't need a lawyer who is very good at litigation to become a judge, as long as the lawyer is experienced in his field and he has been regarded objectively as a good lawyer, then he should be a very good candidate for the consideration by the judiciary. And for solicitors, I think timing is very critical, because when the judiciary invites our members to be deputies, only a short period of time would elapse between the interview and the commencement of the term. I think the judiciary would understand in which month more judges would want to go on leave and in what month you would need more help. Say if you have an interview in January, if you allow the lawyers to have 6 months' time to clear their diary, to sort out their diary, then many people will be interested to deputize. Currently, you have the interview this month and then you're expected to start work next month. Then there will be a problem. It's not that they're not willing to do it, but they can't clear the workload they have with them currently.
So I would like to suggest, concerning the interview and before they actually take up the appointment, perhaps there should be more lead time. As for the special magistrate or deputy special magistrate, they cannot hire enough people because I understand the daily pay is way lower than those working in the court. Counsel on field duty lawyer, that is. And I am sure this is one major reason why people are not interested in being deputy magistrate. So we have to consider the pay level. Thank you, Mr. Heung. I have decided to extend the meeting by 15 minutes because 5 members are waiting to speak. Mr. Langabiu. Thank you, Madam Chair. Concerning the pay adjustment, we are in favor. I think we are concerned about the accumulation of cases for our judges. According to the review report, Table 1, well, maybe it is not the most updated version, but there is indeed a gap between 193 and 154 between the establishment and the actual number. We're talking about a shortfall of more than 10%. Is that normal? Or is it something that we need to work harder on resolving? The President has made a number of very useful suggestions, and we should consider all those suggestions. So according to the figures, the judiciary is understaffed. Is it the norm or has something gone wrong? And what about retirement age? Can we push it back? How is the judiciary handling this? We're talking about very experienced judges who are serving in their 70s. But in terms of the entire system, we need to ask some questions. 60 or 65 and can be extended to 70, and you can predict how many judges are about to retire. Have you actually talked to the JJOs whether it is feasible to postpone the retirement age? What is the major concern? Finally, the arrangement that prevents judges from joining the private sector after retirement unless they get the CE's approval. Has such approval been given during this current administration? I want to take the third question first. According to my knowledge, during the current term of the government, no such approval has been given. Going back to the first question, every department, 193 is the establishment. Well, there will always be a shortfall or a discrepancy at different levels in all the departments. You see a shortfall of 23. It seems like a big number, but according to the judiciary, about 9 positions are not filled because the court in West Kowloon is not yet completed, and therefore we are not ready to recruit such JJOs. So if you do the deduction, we're only talking about a dozen unfilled positions, which is comparable to other departments. It's not particularly serious. Secondly, we have talked about the establishment of 193 people. Is that enough? According to the established procedures, we're opening 7 new positions in the past. In 2008, there was a comprehensive review on judges, and 8 new positions were created in the past few years. Every year, 2 positions have been created for the Land Tribunal, competitive matters, and then finally you asked about retirement age. According to the judiciary, for Chief Justice, there is actually a study on the proper retirement age. Should it be 65, 70, 71? Can we allow flexibility to push the retirement age back? Something is being done at the moment. Okay, we have to make better use of the time. Ms. Emily Lau. Thank you, Madam Chair. We're all very concerned about this. Pay increase, is it enough to attract and retain the right talents? The Law Society has proposed something for the administration to consider. If possible, maybe you should consult the judges. Is there such a mechanism? Do they have the chance to express their views? If you look at the number of positions, 193 positions according to the establishment, and 170 are filled, and Finance Committee is about to approve another 7. So there's a gap of 20 odd or even 30 odd. You always find someone to do it on a temporary basis. And according to the paper, you said that the judiciary is not saying that the current situation is very difficult. But maybe perhaps not too many people are attracted in the first place to join the bench. We need to do something to attract more people, because think about the waiting time. You can't provide a clear answer concerning the waiting time before you can appear in court. We sometimes have meetings with the Chief Justices. Perhaps we can all sit down and talk about this in our next meeting, because we are all concerned about this. So according to the figures, you're saying everything is fine, because by November we have 170 JJOs. But you should fill 193, right? Well, as I have said, about 9 positions are not filled because the West Kowloon facilities are not yet completed. So we cannot fill those 9 positions at the moment. In para 7, you see the March figures. And if you look at November figures, we are talking about 20 we will not have such a great demand for the temporary judges. We have actually completed one recruitment exercise for the magistrates and also CFI judges that only started in October. So we have to see if people are interested. We have to examine the quality of the applicants and then go back to the pay adjustment mechanism. As for magistrates, after the recruitment exercise, 16 magistrates have been appointed successfully, together with 5 special magistrates. So 21 positions have been filled. They will make the necessary announcements very soon. But I'm not representing the judiciary, and I cannot say whether the recruitment exercise or the retention plan is working very well. But if you look at the level of remuneration, all the relevant parties are paying close attention, especially for the recruitment this year. They talked about seeing some signs, whether these signs will turn into a trend that requires some fundamental changes to the pay package. We will pay close attention. What about the judges? Are they allowed to express their views? Is there a mechanism? Well, every year when we conduct the pay review, the position of the judiciary is one of the 3 major factors. And I trust that the administrator does consult the judges. In para 21, I think it mentions that point. Mr. Heung. The judiciary is understaffed and it's difficult to recruit people. It's not a new problem. And in para 8, it's telling us that it is becoming more and more alarming for the legal profession, for people who have to work in courts all the time. They have seen this problem for a very long time, especially for CFA judges. The waiting time, Kitty, you should know very well that this is a long-standing problem. Today we're talking about pay increase, but staffing problems have been discussed for many years. The president of the Law Society suggested that we should recruit more people with legal background and the right training. Young lawyers or solicitors, we should recruit them to be judicial assistants. Actually, last year, I have proposed to the administration that there should be more such positions for young lawyers to enter the profession, to learn and at the same time provide assistance to the judiciary. I would like to state this one more time. I urge you to consider expanding the judicial assistance scheme. We also talked about the retirement age. I don't want to repeat the same point. I understand that the judiciary is already conducting some study. Thirdly, about training for judges, or continuous learning for judges. Early this year, the judiciary came to our panel meeting to talk about Judicial Institute. We are waiting for details on training for junior judges. Fourthly, difficult to hire the right talents. It's not just happening to the Court of First Instance, but also at different levels of magistracies. The president of Law Society also said that if you are to engage special magistrates, what you offer is simply not attractive enough, because they have to leave their work as a solicitor or a barrister for 1 year, 2 years, to join the bench. And when they leave, they cannot go back to the original position. But afterwards, even if this person performs very well, you do not appoint this person to be a magistrate. So people feel reluctant when you invite them because their career path and the pay level are not attractive. Of course, they want to serve the local community, but I think you need to offer a more attractive package to attract the right talents. We've talked about this many times. Too bad the judiciary is not attending this meeting. So, can you confirm resources needed by the judiciary will be satisfied upon their request? Ms. Choi?
Thank you, Mr. Kwok, for your question. Well, I'm not the FS and I'm not the Treasury, but I can share some information with you. Since the year 2011, for 4 years in a row, in the budget, resources requested by the judiciary have been allocated in full. So few government departments have been able to get 100% of what they have bid for. And then for the year 2014-2015, 66 posts have been created for the judiciary. The Law Society also talked about the adequacy or otherwise of support staff. If we create when we have 7 additional judges, then we create 16 posts for the purpose of supporting the judges. Sorry, Ms. Choi. I must give the floor to Mr. Ng Sing. Madam Chair, I basically support the paper itself. Judicial independence. Of course, we insist that the principle should be upheld. And then the legislature and the judiciary should respect each other on a long-term basis. And from recent court decisions, I think basically this is being observed. I think we still want to make sure that judges are well paid, so as to make sure that they are clean. I think this is what we do in capitalist societies. There's no way that we can compare the judicial pay with the private sector earnings. I think it's difficult to compare. It is impossible because circumstances would change and it's difficult to tell whether it is reasonable or not. So I don't think we should compare the judicial pay with that in the private sector. Certainly, if I may comment on the work environment, I think we are all concerned about their workload as well as their support staff. I agree that it should be reasonable. Otherwise, judges would find it difficult to cope. So basically, I agree that there should be a reasonable increase. And then Mr. Kwok said that he was concerned about the training. I think we should understand the national circumstances, the sentiments of the society and the sentiments of the people. Sometimes we wonder whether judges have sufficient exposure. Maybe judges are legally qualified. But what about changes in the national circumstances? What about changes in the society's sentiments? What about the people's aspirations? So perhaps judges should be given training and in this regard, and I think the government is still bound to do so. Ms. Choi, thank you, Mr. Ng, for his questions. But at this stage, I'm afraid I don't have the information, in particular training of judges, if we are to set up the Judicial Institute. Perhaps at this stage I don't have information to answer such questions. Can I give a supplementary answer afterwards in writing after consulting the judiciary? I think everybody is concerned about this. We have got many rapid changes in the society, including the social movements. So the judges should be given ample opportunity to be exposed to changes in the national circumstances, the sentiments of the people, and the opinions of the society. So please reflect upon them and please work on them. Now it's my turn to ask my questions. I think we have talked about this in the past. For a lawyer to join the bench, I think there is the satisfaction, the status, and there is greater security. But then it is a major decision because it is tenure for life. We have always regarded being a judge means to enjoy high status. This is attractive to many lawyers. So I want to know about the recruitment process. Well, to become a judge, you have to be very committed to join the bench because your rulings will affect the society a lot. Now, often have I heard that there are recruitment problems. Now, for the magistracies, I agree that the pay is really too low, and even for the court of first instance, I suppose the pay levels are attractive enough. And then for lawyers with experience 10, 15 years, they're very interested to join. But then it seems that they don't get the opportunities. It seems that they have to be invited, they have to be recommended. So in fact, in the private sector, there are quality lawyers, they are dedicated lawyers, but they don't have access to join the judiciary. So do they have head hunting for judges? Of course, they are at a more senior level. And then for other organizations, for very senior positions, they would ask for the help of the head hunters. We hope that there will be qualified support for the judges. The judges have to write the judgment as well, so it will be good if they can get support from staff who are legally qualified. And then for the judgment in Chinese, now in many cases we don't have the Chinese version of the judgment, and sometimes even if they are available, we always have to refer to the English version. So what is your comment on this? Thank you, Madam Chair. Madam Chair, I'm sorry. What you have asked are really the internal arrangements of the judiciary. I'm afraid I cannot answer the questions thoroughly. But then, first of all, I think all the recruitments are open recruitments, in particular for the case of magistracies, and also the recruitment, the current recruitment exercise for judges of the court of first instance. I think you can get the information on the website. For judicial assistants, it was supposed to be a pilot scheme. We try to ask outstanding law students to carry out research on points of law. As to whether the finding of the review is to expand the scheme, I'm afraid I have to get more information before I can give you an answer. As to the Chinese judgments, I don't think I've got the information with me. I think the panel would like to follow up on such matters. Next time, we must make sure that the judiciary is present as well. Mr. Dennis Kwok would like to ask questions for a second time. So I'll just give you 1 minute just to tell us what you find it most pressing to say, and then Ms. Choi will answer your question. Just now, Mr. Leung Sing has said that judges have to understand the national circumstances and should also understand the sentiments of the society. I just want to say that I don't want to see this happen. Judges are trained, and for the Judicial Institute, I don't think that's meant for that purpose. For the Institute, it is to help them to handle the court procedures. It's about the ethics as a judge, and also to enhance the legal knowledge. And that's the rationale for supporting the setting up of a judicial institute. It's not to familiarize the judges with the national circumstances. Leung Sing, just 1 minute. Well, judges have been criticized for living in the ivory tower. So I hope that they know something about it, so that when they make a judgment, it is based on real life. What is important is the perception of the society. Now, if judgments of the judges are not always accepted, if it is up to individuals to choose which judgment to be bound by, then it is not good. Well, I think basically you want the training to be done for the following purposes, like keeping up with the international trends, and then we will be interested in the work of other jurisdictions, like mutual legal assistance with the mainland one day, etc. I think we would like to update our judges, and we hope that they know about the global trends as well as the regional trends. I think that's what we talked about in the past. In the second quarter of 2015, the Director of Admin and the Judiciary will be invited to come here. We do support creation of posts, and then if they can tell us about their difficulties, then the panel will be more than happy to help. And at the same time, we hope that they will show us their respect. They should also be present at our meeting and not just have the Director of Admin here. Well, this is about the judiciary. We want to maintain the independence, and that's why it is the administration wing to present to you the position of the government about their pay adjustments. That's why the judiciary hasn't come. Now, in the second quarter, when they talk about their manpower, when they talk about unrepresented litigants, I'm sure the judiciary will be very happy to come here and explain the policies to you. All right, we look forward to the discussion in the second quarter. Mr. Heung, I hope that the administration can consider the following. That is the building of the High Court. I think it has a history of 30 years. In today's world, if we ask the administration to give us a piece of land to build a new building, it is unthinkable. But then perhaps we should consider the future of the High Court building in 20, 30 years' time. Now, it seems that a judge cannot have the so exclusive use of a particular courtroom. They have to go around like gorilla. I think you need to take this up. Yes, thank you, Mr. Heung. Indeed, we did raise the question of inadequate space and not enough courtrooms. The panel do hope that everybody will try to help with the development of the judiciary. In particular, if they can take on more talents, cut down the waiting time, we'll be very happy to be of help. We also hope that the administration wing will relate our views to the judiciary. We will try to make an arrangement. Last time we met with the CJ and we thought that it was good, and this year we want to do the same. Here I would like to thank Ms. Choi for coming. Thank you Law Society, thank you Bar Association for coming, and thank you members for staying behind. Meeting adjourned. Do we have the support of the panel to go to the FC? Yes, let me just ask if members would object to it. I think we've said many times that we are fully behind you. Thank you.